I'm Vivian Hamilton. I'm an associate professor here at William & Mary, and it is my pleasure to moderate this panel. Are juries made up of experts or the ill-informed? I have no idea who structured this conference, but it's pretty brilliant that this panel, I think, follows the one that we just had, which addressed our normative commitments to jurors and our faith in their capacity to decide cases. And now we turn to some empirical-based questions about juror competence and, in some cases, whether jurors may have too much experience. And we will hear first, actually, I don't think we've decided in order.
Whatever you want.
All right, well, let me just introduce our panelists, and then they can decide who will speak first. So Ilya Somin is, oh, my bad. Somin is a professor at George Mason Law School and writes on constitutional law, property law, popular political participation, and constitutional democracy, and co-edits the Supreme Court Economic Review. To my right is Sherry Seidman-Diamond, who is a professor of law as well as psychology at Northwestern, and is also a research professor at the American Bar Foundation, and has conducted a lot of important empirical research on the jury process and juror decision making. So with that, our time is short, and so I will turn it over to one of them.
I think I'm being directed, and I always follow instructions.
All right, sorry.
Some, when I like.
All right, so I have limited duties as a moderator, and I've fallen down on one of them already.
It was over your shoulder, not familiar. No, okay. So first of all, I want to say thank you very much. I have a thing to say thank you about that I'm ambivalent about, which is I have now consumed half of the jar of Virginia peanuts that we were in our welcome bag. So I think I'm thanking you for that, but I'm not entirely sure about that. So. The conversation for this panel is about two extremes, and I think it's important to characterize the jury as neither one nor the other. It's, in fact, very much a combination of about the, great unwashed middle. But what I'm going to talk about is one end of this spectrum that this panel represents, and that is about embedded experts on juries. And my collaborators, Mary Rose and Beth Murphy, are not with us today, but they are a very important part of this project. The changes in the jury trial over time are really quite substantial. I think Akil referred to the fact that our jury composition has changed over time. The very early jury was composed of white male property owners, a very limited group. And over time, we've seen a real expansion here so that most of we have broader eligibility, both with respect to race and gender. And we also have eliminated most of the occupational exemptions that, in fact, for some time we had. So over time, we got this proliferation of occupational exemptions, and the modern jury has gone quite in the other direction in the form of jury reform and has eliminated most of those occupational exemptions. At the same time, we've seen a development, particularly in the civil trial area, of an increased use of expert witnesses and technical expertise on the witness stand. So these kinds of changes have have changed the balance, arguably, about what is going on between the jury and what is going on the witness stand. I'm going to be talking about three very different kinds of data sets, but one of them is from the Arizona Film Jury Project, in which we were able to film videotape 50 actual jury deliberations. So the part of it that's from this is the post-trial questionnaire that we asked the jurors. Was there anything in your background that gave you particular knowledge or expertise in serving as a jury in this case? And 20% of the jurors claimed that they had specialized expertise. Now, when we asked them what it was, sometimes they said things like, I'm a parent, I drive. We didn't include those in this specialized knowledge expertise category, but 12% of them mentioned that they had occupational or educational background. And we could also infer from others that they, in fact, had specific occupational experience. That is, a nurse on a medical malpractice case would be an example of that. Okay, so then I said, well, are these weird cases here in Tucson, Arizona? And I spoke at a national session of trial attorneys, and I asked them about their most recent trial and whether they had had any people in these occupations on the trial. And this is the result I got, an average of about 2 jurors per trial who had some potentially relevant, case-relevant experience. So but on the other hand, what we're talking about is case-relevant experience, and you could say that a nurse might not have case-relevant experience if it wasn't a personal injury case or a medical malpractice case. So when you match them up, the question is, were you going to have this kind of matchup? And this is the interesting pattern that emerged. That is, if you compare the medical malpractice cases with other cases, you actually had more people with, well, you can see it. It's the one on the left, right? The medical malpractice cases were more likely to have somebody with a medical background than other cases were. The PI tort cases were more likely to have somebody with a medical background than other cases were. And the products liability cases were more likely to have somebody with an engineering or mechanical background than the other cases were. These are small samples, and I put up there, you can see that they're not at conventional levels of statistical significance, but they're exactly the opposite direction that you might have expected. When I talk to some attorneys about this, they say, well, yeah, if I have the good side of the case and I think the facts are on my side, I wouldn't mind having somebody with a little bit of expertise on my case. Okay, so this is what's going on out there. It's a very confusing setup, however, for jurors. On the one hand, jurors are told, you will decide based on the facts from the evidence presented in court. And they're also told, consider all the evidence in light of reason, common sense, and experience, right? Somewhat not straightforward about what they should be doing with their background. And you can see this is from the jury deliberations in Arizona. This is a juror who is trying to follow the instructions. That's another thing. One of the things I was listening really carefully, they didn't say. They said 2 things that kind of confused me. They said we can bring our experiences, got that right, to bear, and our judgment. They also said you can't use any evidence that wasn't introduced. Right. Now I sit here and I think of a lot of reasons she should have said that. But, you know, what about this? What about this? Can we consider those things? Very unclear. Well, this is our attempt to see whether the jurors with specialized knowledge in the Arizona juries were exerting undue influence or behaving in ways that would be potentially a problem. These are some indices that we can use across cases. What we find is Rated influence, no difference between the expert jurors and other jurors. Of course, self-report is never an entirely trustworthy measure. Were they more likely to be forepersons? No. Were they more likely to be the source of a first proposal for what the verdict should be, either on liability, damages, or split of fault? No. Source of a final proposal, that is the one that the jury actually came up with? No. More likely to call for votes? No. More likely to engage in probing jurors, other jurors for information? No. Holdouts. These are non-unanimous juries. That is, they don't have to reach a unanimous verdict. And the question is, if these were exerting undue influence, you might expect that the professional jurors, that the juror experts would be less likely to be holdouts because they were bringing everybody along with them. In fact, it goes in the opposite direction. They are more likely, somewhat more likely to be holdouts than the others. But there are differences between the jurors with specialized expertise and other jurors. So they talk a little bit more. They're more educated on average. They make more correct references to jury instructions. They're more likely to correct errors in jury instructions. They're more likely to make references. They make more references to experts, which is in fact consistent with their expertise. But the one that I find most interesting, we constructed an index which said, was a juror kind of one-sided, or did they have a more mixed kind of discussion of the evidence? And we coded all of these 78,000 comments on whether they exhibited a valence favoring the plaintiff or a valence favoring the defendant, what one side would have liked to hear. I'll give you some examples of these. These are pro-plaintiff examples of valence. Yeah, these are good things. The plaintiff would like to hear these things, right? How much would it take to compensate you for the rest of your life? Yeah, that's the plaintiff wants to hear those. The pro-defense things, well, she wasn't wearing a seatbelt. She didn't follow the instructions the hospital gave her. All of these things the defense wants to hear, right? Which is outrageous in terms of how, as far as I'm concerned, in response to the claimed need for a length of treatment. Okay? So if we go back, I can go back, right? These are differences between the experts and the others on the extent to which, at the bottom of this, they are one-sided. That is, their valence comments are 90% for one side or the other. And the expert jurors exhibit more complex kind of conversation, are more likely to have conversation that is not one-sided, half as likely as the remaining jurors. Okay? So, what is appropriate use of expertise, right? This is from the third data set from this paper, and that is a series of little vignettes that we gave to judges and attorneys at a federal circuit conference. And I also have done it with some state court judges. And this is an example. This is a motor vehicle tort case. Jurors work for the insurance company for 20 years and tells fellow jurors that the award they make won't be taxed. This, of course, is irrelevant. But it is in fact accurate. So we asked the attorneys and the judges whether they thought the juror had misbehaved, not whether the case should be set aside if this information came to light. That's a different story, but whether the juror had misbehaved. And this is had behaved correctly. I didn't say that. This is 19% thought that the juror had behaved appropriately, and 10% of the attorneys said yes. So they were disapproving of this juror's behavior. This is a more complicated kind of case. This is one of the cases similar to something that happened in the Arizona project. In a tort case, a physician on the jury convinces her fellow jurors that the medical expert who testified for the plaintiff was incorrect in claiming that the plaintiff's injury made him more susceptible to a viral infection that he contacted 6 months after the accident. Question is the juror, has the juror behaved appropriately? This is judges saying 44% saying that the physician had behaved appropriately, and attorneys 32%. Now, I have a whole series of these, but my point here is that there is a mixture of response here in this. We haven't committed ourselves to what is appropriate behavior. And if you go through the legal background on this, you can find cases from different states taking very different views about the propriety of juror behavior when they use their kind of background occupational expertise. Now, you can clearly learn about occupation during voir dire, and some courts have taken the position that you waive concerns about any kind of occupational behavior when the parties had an opportunity to vet the juror and voir dire for that form of expertise, but arguably modern voir dire is limited and challenges are limited. Now, one response that a couple of scholars have suggested is that what we really ought to do is expand the challenge for cause to be able to remove jurors with occupational expertise. Now, to me, that is an amazingly big red flag. And for this conference in particular, where we're talking about the jury as a political institution, when you look at the data from the Arizona Jury Project and you see some contributions being made by these jurors, you're talking about removing part of the jury pool where we've worked so hard to get a more diverse jury pool. And that includes not just race and gender, but should also include occupational background. So this is the position that the poor New York courts have taken on this. And I say the poor New York courts because it's in response to a case in which it was a homicide case, and the question was a murder charge, and two nurses did some influenced, apparently, the outcome of the case. And it came to light from a newspaper, enterprising newspaper person. And the trial court set aside the jury verdict and ordered a new trial. It went up on appeal. The appellate court said, there was voir dire, and they knew they had two nurses, and there was going to be medical testimony, and said the jury verdict, it was a conviction in a criminal case, was just fine and dandy. The highest court in New York took a different position and, in fact, ordered a new trial, saying the jurors had misbehaved by using their background expertise in the course of the trial to interpret the testimony by the expert. So New York instituted this kind of instruction. Although as jurors you are encouraged to use all of your life experiences in analyzing testimony and reaching a fair verdict, you may not communicate any personal professional expertise you might have or any other facts not in evidence to the other jurors during deliberations, right? So you go sit in a corner, right? And that's the position that they have taken. I think, with my psychologist hat on, I think it is extremely difficult to tell how much of our background information comes from our professions and our occupations, so I think it's really hard to do this. This is what I would suggest, and this is a very, very light touch to add to the kind of treatment of juror expertise. This is a modest point to be made to give attention to the fact that these jurors, in fact, are not experts and are not being cross-examined. I've tried this out on some judicial audiences here, and that seems to be the modest a point. But for our purposes, and then there is the issue about if you have expertise in law, go ask the judge, right? I mean, the judge is sitting there in the courtroom, and you can, in fact, ask the judge, right? So finally, for this symposium, the key here is what do we want the jury to look like? I think we want it to look as broad and as inclusive as it possibly can be. And I think juror experts, quote, experts, are a part of that picture. Thank you.
Thank you. Now we will hear from Professor Somin. Thank you.
I'd like to start by thanking the organizers for putting together such a great conference and all of you for braving the weather to get out here on a Saturday morning at a time when I at least normally would be asleep. So I commend you for doing that. I think, like Sherry, I'd like to start out a little bit by perhaps questioning the premise of the question in the panel, and I think experts versus the ill-informed is in many ways a false dichotomy. Just about all of us are experts in a few things and ill-informed about the vast majority of human knowledge that's out there. That's true even of the smartest, best-informed people that we know out there, people like Einstein or Newton or even Akhil Amar. They're tremendous experts in some areas they know a lot, but the vast majority of human knowledge is necessarily closed to them and to us because there's just too much of it out there. So I think the real question is, to what extent are jurors or anybody informed about the particular facts and issues that might be relevant to making the decisions that they have to make in that context? And in talking about that, I'm a little conscious about it of an irony in that I myself am certainly not primarily a jury expert. Unlike most of the participants in the conference, I write primarily about other fields. I think the reason why I'm here, other than that they had to have another slot at the conference and give it to somebody, is that I do write a lot about political knowledge, the knowledge that voters have when they go to the ballot box, and whether their knowledge is adequate. And a lot of evidence suggests that in many contexts they are not, or their knowledge is not. So I think a key question, given that this conference is about the jury as a political institution and as a mechanism for popular participation in government, is do jurors have some of the same knowledge problems as voters do, or is there reason to believe that the jurors are in fact in many ways better and that the situation is such that it's more likely that they have adequate knowledge? And to my mind, I think this is a very important question that does go to the heart of at least a lot of the reasons why we might want or not want jurors to make particular decisions. In my forthcoming book, Democracy and Political Ignorance, which my publishers demand that I mention every time I speak, so I'm going to do that. It'll be out in the fall from Stanford University Press. There's no need to read it, just buy it. That's my only request. In that book and in some previous writings, I identify two kinds of problems that voters have in terms of acquiring sufficient knowledge and also in terms of rationally evaluating the knowledge that they do have. And in the first part of the presentation, I'll talk about those and also about some reasons why we would expect jurors to do better. In the second, I'll talk somewhat about the evidence on the jurors and their knowledge and bias or lack thereof, which I think is a mixed bag. I think in certain kinds of complex cases, there are real problems, whereas in many others, the evidence suggests that at the very least they do as good a job as judges potentially do in this area. Finally, I'll talk a little bit about proposals that are out there in the literature to use the institution of the jury to participate in a wide range of more policy-making types of decisions as opposed to merely deciding cases in the courtroom. I'm going to suggest that those kinds of institutional proposals, they actually are more likely to put the jurors into situations where their knowledge will be inadequate as opposed to certain kinds of trials, many trials where the knowledge might work reasonably well. So first, what are the potential problems with political ignorance? Well, one big problem is that voters actually have very little incentive to acquire political knowledge. As Akil Amar pointed out yesterday, the chance that your vote will make a difference in an election is infinitesimally small. It's actually slightly greater than zero. If you're interested, I have an article where I discuss in some detail what the odds actually are, but in a presidential election, it's about 1 in 60 million on average. In some other elections, it's a bit higher, but still the odds are very low. So if your only reason to acquire political knowledge is to be a better voter, to choose the right candidate, that's actually not much of an incentive at all. And that's why many economists and political scientists and others posit that voters have incentives to be rationally ignorant. It's actually rational not to devote a lot of time and effort to acquiring this knowledge because it won't make much difference anyway. And the overwhelming evidence that I review in my book and is reviewed by other scholars suggests that indeed in a lot of issues, voters possess very little knowledge, both about particular policy issues, about particular politicians, or even about the basic structure of American government. So for instance, a Zogby poll in 2006 found that only 58% of the public could not name the 3 branches of the federal government, the executive, the legislative, and the judicial. Immediately after the 2010 midterm election, less than half the public surveyed by the Pew Research Center knew that the outcome of the election was that the Republicans had taken control of the House, but not of the Senate. And I can regale you with dozens and dozens of similar examples like this. If you like this sort of thing, yes, you should read my book. You knew I was going to say that. But for now, I'm going to press on and suggest that there's a second problem, and that is that with the knowledge that you do possess as a voter, certainly almost everybody knows some things about politics, it also turns out that there's not much incentive to evaluate it in a rational and unbiased way. Because again, the chance that your rational, unbiased evaluation will make a difference is extremely low. And lots of evidence suggests that, in fact, voters analyze political knowledge in a highly biased way, overvaluing any evidence that reinforces their pre-existing views, and downplaying or completely dismissing evidence that cuts against them. This, by the way, is particularly true, ironically, of those voters who actually know more and are more interested in politics. Why? Because those people tend to have stronger partisan commitments or stronger ideological commitments, and that makes them more biased in the evidence that they consider, and also they tend to only talk to other people who have the same views as they do, only read or watch media sources that have the same views, and so forth. In the article and in previous work, I analogize this to the situation of sports fans. I'm a big Boston Red Sox fan. I know a lot about the Red Sox and about baseball in general. I also hate the New York Yankees. I think that's actually an entirely rational form of hatred, but obviously it doesn't make me completely unbiased. Thank you. In my evaluation of evidence about them, political fans, as I like to call them, often operate much the same way as sports fans in this respect, and there's a lot of evidence to support that position. So economist Brian Kaplan likes to call this rational irrationality, that when your reason for being interested in activity is not primarily truth-seeking, but to enjoy the fan experience or some other motive, it's actually rational from your individual point of view to be biased in your evaluation of the evidence, because it's not that you're deliberately believing things you know are not true, it's that you're not trying very hard to check up on the truth of what you believe. And I think that's the way a lot of people do approach the way they look at politics. Now, the question arises, what about juries? Are their incentives the same? In some respects, perhaps yes, in that jurors, like voters, most of them, there are obviously the embedded experts, but on the whole, most of them are deciding issues that they don't know much about beforehand, haven't spent much time studying them, and they don't have much of a direct material personal stake in the outcome. If they did have such a stake, presumably they would be dismissed for cause in most cases. However, I think there are also huge differences. The biggest one is this. On most, if not all, civil and criminal juries, the number of jurors varies from 6 to 12. And in the final version of my paper, I'm going to have a little calculation of what are the odds of casting a decisive vote. But for now, what's important is to note is that the chance of casting a decisive vote is vastly greater in a group of 6 to 12 than in a group of thousands or millions. And that, I think, does lead people to take the task more seriously. Secondly, in most cases, jurors decide much narrower issues than voters do in an election, say, for Congress or the president. There's an enormous scope of the government, and it covers an enormous range of issues that even those voters who know much more than the average, they probably only know about a few of those issues. By contrast, most trials focus on a discrete set of facts or discrete set of transactions, though as I will note below, obviously there are cases that are exceptions to that. And then finally, of course, the jurors do have to listen to evidence over a period of time, and they do have to listen to both sides present their case, and that at least somewhat, I think, diminishes the likelihood of bias. So I think there's some reason, in many cases, good reason to believe that voters will suffer from this knowledge and bias problem. Jurors will suffer from it less than voters do. And if you look at the literature, which much of it produced by some of the other participants in this conference, I think in many cases we indeed can show that jurors either do well or at least do no worse than judges. There's a large literature on judge-jury agreement about case outcomes and other issues, and much of it shows that 70-80% of the time, or even higher, the jurors come out the same way as the judges do. And I think that's important, and it does show that they handle these tasks reasonably well. I do have one caveat, however, and that is that, like jurors, most American judges are generalists, and they're not experts often in the particular areas of law that they focus on. So one of the other areas I study is property law, and when I read decisions, even of the Supreme Court in that area, not only do I think that they often get it wrong, but in some cases, I think the judges, even the ones who agree with me about what the case outcome should be, display significant ignorance about what's actually going on in that area of law, and I wonder to what extent that's actually true of trial judges as well in some cases. So in some instances, it may be that judge-jury agreement reflects not knowledge on the part of the jury, but ignorance on the part of the judge, and I think that's, at the very least, a possibility to consider in some cases. Nonetheless, despite that caveat, I think the judge-jury agreement literature is impressive and does show that in many instances, juries do reasonably well. However, there's also evidence elsewhere in the literature, particularly for more complex types of cases, which do suggest some real problems, some due to ignorance and some due to irrational evaluation of the evidence that's put before juries. So I think Kip Viscusi of Vanderbilt and his colleagues have some good studies where they look at risk assessment by jurors opposed to by judges, and although both jurors and judges do make mistakes, hindsight bias or miscalculating on risks and the like, nonetheless, on the whole, you find that the jurors do a poor job. One of the findings that particularly struck me is that the jurors, but not the judges, are likely to award higher damages against a defendant firm if the firm has actually done risk assessments ahead of time where they decided that a particular course of action was cost justified despite the risk of lawsuits. Now, this, I think, is exactly the opposite of the incentives that the tort system is intended to create, in that we want companies to take account of risk ahead of time as opposed to acting based on intuition or the CEO's gut judgment of whether a particular risk is worth it. And if we punish people, in effect, for doing risk assessments, we do a disservice not only to the firm but also to the goal of minimizing injuries over time. And there's also a literature to which actually Sherry Seidman-Diamond is an excellent contributor about the extent to which juries often misunderstand judges' instructions, and a lot of that suggests that it's pretty common for them to misunderstand. In Sherry's excellent recent Northwestern article, she found that such misunderstandings happened in 96% of the sample of 50 cases that she studied. Now, it is also true and important that she also found in only 7 of those 50 cases that those misunderstandings have an impact on the outcome. I think whether 7 out of 50 is a big number or a small number depends on your point of view to some extent. I didn't find it enormously reassuring because it's almost 15% of the total. Others might find it more reassuring, and obviously both 7 and 50 are relatively small numbers, so you want a larger sample, but both that study and others at least suggest that there's reason for cause for concern. There are also studies of bias as well as ignorance as such, particularly in things like punitive damages awards and the like. I'll mention one that I thought was particularly interesting, a recent article by economist Scott Wentland, where he found that in assessing tort damages, juries in jurisdictions which had a higher percentage of Democrats as opposed to Republicans, there are much larger damages awarded, some $157,000 larger on average for each standard deviation in the number of Democrats opposed to Republicans. So this suggests either that Democrats show political bias in favor of higher damages or Republicans in favor of lower ones, or both. I don't think you can tell if both groups are biased or just one, but at the very least, I think that kind of finding is troubling, and that the amount of damages should not depend to this extent on the political views of the jurors. And this, I think, is perhaps a similar phenomenon to what we see with regards to the analysis of political knowledge by voters, where there often is huge ideological bias in the way that they analyze it. Finally, there's also literature on expert witnesses, where again, jurors sometimes have significant trouble there. It is true, as we heard in previous panels, that sometimes jurors have trouble because the expert witness did a poor job of explaining their arguments and the like, but still, we would want to have a jury that decides between the expert witnesses, not based on the quality of their presentation skills, but actually based on the extent to which expert was closer to the truth. Ideally, that's what we would want to look for. So I think my impression of this, and I'm still working through this literature, and I'm sure I'll have many refinements in the final paper, is that in a large number of cases, perhaps the vast majority of jurors do reasonably well, but there are certain categories of more complex cases where there's complicated risk assessment or complex expert testimony and the like, where the jurors don't do as well because those cases are A, complicated in some of the same ways that the political system is complicated, so you have some of these same problems with political knowledge, and secondly, the more complicated the case is, the less likely it is that simply paying attention over a period of time or taking your job seriously will be enough to overcome your initial lack of knowledge about the issues at stake. So I think this sense has important implications for the last thing I want to talk about, which is various proposals to use jury-like mechanisms either to make political decisions or to try to inform voters better. There are many scholars who have proposed this. Among the best known is Bruce Ackerman and James Fishkin's book, Deliberation Day, also an excellent book by Ethan Lieb, who's a participant in this conference, and a proposal by political philosopher Jamie White. There are many variations in exactly what they propose, and I go through some of them again in my book and some of my other writings, but what all of these things have in common is the idea of getting ordinary citizens together, randomly selected ones usually, to talk about political issues and hear presentations by experts on both sides, or sometimes by people from political parties and the like, and then to try to make some sort of decision. And I think what most of these proposals have in common is that they actually look much more like the complex types of cases where jurors have trouble than the simpler ones where they might not, in that they involve usually fairly broad and complex policy issues, and also if the idea is to get them to deliberate about choices between candidates in an election, the issue is not even just one issue, it's a whole wide range of issues. So I think the problems of both comprehension and bias are likely to be significant there, especially given that the issues here are likely to be ideologically charged. They're more like the damages study that I mentioned than, say, a whodunit type of a case where there's not much ideology involved. And there's obviously other serious problems, such as that whoever structures a deliberation has to choose which experts will get to present, which issues will be on the agenda, and so forth. So it is not my view that these sorts of deliberative experiments are completely useless and should never be done. But I would be skeptical about placing heavier reliance on them, either to make policy decisions or to believe that they will offset the problem of political ignorance. That said, I do think experimentation with them is desirable, especially small-scale experimentation. So on that note, I conclude, but I very much look forward to discussion, especially to learning more from the many of you who are much more expert about juries than I am. Thank you very much.
Thank you. I think we have just under 10 minutes for questions. Professor Lee.
So one thing for each of you. For Barry, I just was noticing the perspective. I hadn't looked at it in the paper, but the New York instruction that you put up actually asks for the jury to reach a fair verdict, and your replacement for that instruction says nothing about fairness. I thought that was kind of interesting.
That's a good point.
Second,
I have to put fairness back in. Definitely have to put fairness back
That was a very fair comment.
maybe the jury isn't supposed to be fixated on fairness. I don't know. But anyway, for Ilya, I don't know, I was kind of pulling up the Viscusi studies because while you were talking, because I was interested in their design. And this is something, obviously, with the panel is worth talking about, and we haven't spent a lot of time talking about methodology in how we think about what jurors are doing and what they can do with their competence. And frankly, for me, too many studies, like the Viscusi study, are just a bunch of surveys asking people sitting in front of a computer or sitting in a lab to tell us what would you do in a case, and I'm giving you a paragraph on the case. I'm not expecting you to sit there for a day and listen to testimony, right? So the experimental situation is highly stylized. More importantly, for the Viscusi study and many, many others that we use in jury literature, the jury never deliberates, right? They're never talking to each other and potentially de-biasing one another about risk. Now, you don't have to be an expert to realize through discussion that maybe you got it wrong on a risk assessment. And so I guess the question is something like, be careful about relying on too many studies that are just survey-oriented and that don't actually involve deliberation. Because for you to be right, and you may be, right, but for you to be right, it has to be that the deliberation doesn't actually increase information or ability to control the risk assessment biases that you're likely to make if somebody just asks you on the phone and gives you a paragraph about what a trial is about.
Yeah, so I think it's certainly reasonable to say that survey studies have that limitation, and it may be in some cases that deliberation will de-bias. On the other hand, there's a lot of studies that suggest that various kinds of deliberations actually increase biases, particularly if people have strong preconceptions based on ideology and the like. Moreover, remember that particular study I cited was a comparison of the judges and the jurors, both assessed the same way. So it may be that the judge's performance will also improve after he's heard all the evidence in a trial. So I still do think that it is significant that there's a large gap between judges and jurors in this respect. And I also think that it's particularly significant that the jurors, but not the judges, will tend to punish the company for making advanced risk assessments. That is the kind of bias that when you look at political knowledge literature like that tends to be fairly deeply rooted. Not saying that there could never be deliberations that would change it. Sometimes they can, but I do think this evidence is significant, even though obviously it's far from definitive and does have its problems.
Can I just go a little bit further with that, because it's an important point. Ilya was talking about our research on the effect of deliberations on understanding the instructions and applying the instructions. And what he didn't mention is about a little under half of the errors that were made were corrected during deliberations. So it's an important point that deliberations can make a substantial amount of difference. The other thing that Ilya pointed out about that study was a suggestion that there were 7 out of, not a suggestion, an accurate statement that there were 7 out of 50 where the verdict was affected. They were all on damage amounts. They were modest amounts in a couple of them. And in a third one, it was the jurors asked a question about the instructions that the judge refused to answer directly and left them with that error in place. So it's very important to talk about procedures that these institutions are embedded in, not just to talk about them in kind of isolation as individual judgments.
No, I agree with that. I think it is important that half got corrected. It's also important that half did not.
Explicitly correct.
Explicitly corrected, okay.
Professor Nelson?
Just a trivial historical caution. A couple of times, both yesterday afternoon and Professor Diamond this morning, mentioned the name of the property qualification for jury service in the late 18th century. And the suggestion is that this really limited the number of people who would serve. At least in the rural north and in places like the Shenandoah Valley, western North Carolina, almost every married adult male was a property owner. You couldn't run a farm unless you were a property owner. So that the requirement of property ownership, certainly kept African Americans off juries, certainly kept women off juries, kept youngish people off juries, but adult white men a fairly broad crossing.
Okay.
I think it's important to be careful about what one says about that, or constitutional originalist arguments can come with.
Professor Abramson?
For Sherry, so it is a mind twister how you handle this embedded expert problem, and the paper shows us why. Just one small question. Suppose a non-expert juror Googles during the trial. Does the same.
Suppose.
Maybe I don't even have to, but the motor vehicle thing, finds out that the award is not taxable and reports that. How do you handle that vis-a-vis the expert who testifies, he's an accountant and he knows this? It's not a difference in accuracy. If anything, it might be more accurate. At least the other jurors can look at it. But I take it we draw the line that that's clearly extrinsic. But the content of the testimony on cross-examined is the same. I don't have an answer to that. There really is a tension between values.
No, there is an enormous tension, and one argument goes that well, there are two things going on. One is the way the law is written now in terms of what is impermissible across all jurisdictions is anything brought in from the outside. So your Google example would be inappropriate. And Paul and I were talking about this the other day. I mean, the question is has it affected the outcome rather than just did he Google as a basis for setting aside the verdict? But so that's one thing. The other piece of it is, when is it going to be more persuasive? The thing I struggle about the juror experts is if they in fact have this credibility in the jury, should we be more concerned about that than if they have the information but not the credential? And it's a very difficult line.
All right, one more question.
I want to come back to the mistake of law issue, because it seems to me that's one that we don't talk about enough. And my one experience on a jury, that was the issue, was trying to get clarification on the law. And when we went back, the judge just read us what she read us before, and it didn't help a bit. How do we deal with that? You can imagine thinking sort of another lay system is if sort of send a written question, but say, no, Judge, I don't understand that. Would you explain it another way?
So there are a couple of things. One is the clerk, of course, is obligated to answer the English magistrate. So we have a situation where there is a relationship there and they can get information. I think the biggest change would be, in fact, if judges weren't, with all due respect, and I don't think you are, the cowards that in responding, right? Because the easiest thing for the judge to do is to say, go back and look at the instructions. I mean, this palpable problem that happened in the Arizona project, the jurors were looking at the page of instructions about damages, and they were they saw, oh, and services rendered, right? And it's in many instructions. And so they said, oh, okay, so attorney's fees are services rendered. But we didn't get any testimony on how much the attorney was being paid. So they submit a question to the judge, and they say, what is the attorney's fee? And the judge comes back and says, go back to page 13 and look at your instructions. And they were on page 13, right? That's where they were looking. And it was completely unnecessary lack of communication. So they added something for attorney's fees because they said, oh, we're just going to have to figure it out for ourselves. They're not going to tell us. I mean, really? So that's the point about having a responsive system that helps the jury get it right.
So a couple of thoughts on this. One is, I mean, I agree with what Sherry just said. I think there are going to be cases, including some in her study, where the comprehension or the lack of comprehension can be solved simply by communication. It strikes me in reading some of this literature, including her paper, that it's almost a little weird to me that people who are experts in trial procedure, they worry that the jury might have too much expertise or have too much communication with the judge rather than too little. It seems to me that too little is more of a problem. So I think there's certainly some problems in understanding instruction that can be solved that way. At the same time, I think there are other problems where the issue is not that there's a discrete fact that the jury doesn't know or a discrete point that can easily be clarified, but where the problem that they're having is part of a larger problem that the particular point they're interested in is embedded. It's hard to understand without having a deeper understanding of the broader law or other points surrounding it. So I think there are some cases where the lack of knowledge can't be remediated that way, and where if a case turns on that, then you might have a real problem that can't simply be cured by better communication. But where it can be cured, and I think in some cases it can, then we should certainly do that. And I think certainly in that case, the judge could have and should have provided a better answers to jury's question than he did, or she did. Okay, 50-50 chance of getting it right.
You have time for one more question.
Okay,
I
thanks very much.
don't know what that means. It's like that, yes, no.